You are about to have your deposition taken. You will be asked a lot of questions, detailed questions about the case you're involved with. The questions and your answers will be recorded and written out. The result will be a written document describing the facts of the case in your own words. What's the purpose of the deposition? Well, the primary reason is what lawyers call discovery, or more simply put, to gather all the facts and information that may pertain to a case. It's an attorney's professional responsibility to learn as much as he or she can in any matter they handle, and a deposition is one procedure they use. Furthermore, during this fact-finding, the lawyer is determining your credibility or believability and how well you will present yourself if you testify in court. Another purpose of the deposition also relates to credibility, and that is to get admissions or contradictions in what you say that can be used at the trial, but more on that later. So, what you say and how you say it is very important and may have impact on the outcome of the case. Will you have to know the answer to every single question? No. Will you have to know and remember every fact about the case? No. Should you always tell the truth? Absolutely. This tape will help prepare you for your deposition. As you watch it, you may have other questions about what will happen or what to say. Jot these questions down and discuss them later with your lawyer. At the deposition, there will be at least 3 other people besides you. 1, your own attorney, who is there to make sure your rights are protected and that you understand everything that takes place. You'll be speaking mainly with the opposing attorney, who will ask the questions, trying to learn as much as he or she can about the case for the benefit of their client. The court reporter's job is to record everything that is said. Be polite and try to relax, but don't be overly friendly. You're there to do an important job.
Would you please raise your right hand? Do you solemnly swear that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
The most important part of your job? To listen closely to the questions and understand exactly what is being asked. After you take the oath, the deposition begins. You are now on the record, and anything said will be recorded. However, the court reporter cannot record nodding of the head, gestures, and other nonverbal communication. During this program, we're going to show you a number of mistakes that witnesses often make, and will demonstrate an alternative way to handle it. Here's an example.
Mrs. Douglas, my name is John Brennan, and I represent Mr. Howard in this case. Now, if at any time during this deposition I ask you a question that you don't understand, please let me know, and I'll try to rephrase it. If you answer my question, then I'll assume you understand it. Would you state your complete name for the record?
Susan Mary Douglas.
Are you married, Mrs. Douglas?
Yes, for 14 years. No, 13 years. 13 years last August.
Do you have any children?
Yes, 3.
And their ages?
The boy's 4, and I have 2 girls. One's 7, and the other one is 2. No, wait, 8 and 2. No, I'm sorry, not yet. One is 7, and the other one is almost 2.
Do your best to stay calm. Take your time answering the questions so you don't quickly give the wrong information, then have to correct yourself. Remember that the result is a written transcript, so pauses before you answer will not show up on the record. Now here are the facts of Mrs. Douglas's case. She is suing defendant Reed Howard for compensation for injuries she received when Howard ran a stop sign and collided with the car she was driving. Even though Howard was the major cause of the accident, his attorney would like to show that Douglas was partly responsible for either driving too fast or failing to stop or looking out once Howard entered the intersection. In this scene, Mrs. Douglas gives the opposing attorney an advantage by volunteering information that goes beyond the scope of the question. This is a common error.
How long had you been driving on Capitol Avenue before the accident?
I think it must have been about 4 blocks, because I had turned left onto Capitol from Main Street. Yes, that's right. That's where the doctor's office is, at the corner of Capitol and Main.
Oh, you were at the doctor's office that morning?
Yes, that's where we were coming from.
When you say we, who were you talking about?
My 2-year-old daughter, Melissa, and myself.
Why were you at the doctor's office?
I'd been up all night with Melissa. Well, the doctor diagnosed it as an ear infection.
In her answers, Mrs. Douglas has gone beyond the scope of the questions and has given the opposing attorney new leads of inquiry, which could hurt her case. 1. Was she distracted by her 2-year-old? 2. Was she inattentive because of a lack of sleep? That's all it takes for a judge or jury to form an opinion or their own conclusions and to possibly weaken her case. How might she have answered differently?
How long had you been driving on Capitol Avenue before the time of the accident?
Let's see. For as long as it takes to go 4 blocks.
I'm not certain, but I think about a half a minute.
Take your time in answering and try to stay within the limits of the question. But on the other hand, do not try to hide information. For example, if a witness is evasive, it may also hurt the case. Mrs. Douglas has testified that she continues to suffer pain in her neck following the accident.
Mrs. Douglas, since the time of the accident, have you gone on any vacations with your family?
We may have gone skiing once.
When was that?
It might have been last winter.
Where did you go?
Vail, Colorado.
For downhill skiing.
Yes.
And did you ski with your family?
I think so.
Mrs. Douglas, do you recall skiing with your family on that trip or not?
Yes, I remember I did ski.
Did you ski every day?
I'm not sure.
Is it probable that you skied every day?
Yes, I guess so.
Of course, Mrs. Douglas remembers that she skied every day for a week, but she's afraid her complaints of neck pain will not be believed. She'll have more credibility in the long run, however, if she's more forthcoming about her activities.
Mrs. Douglas, since the time of the accident, have you gone on any vacations with your family?
Yes, we went skiing in January of 1985.
Downhill skiing?
Yes.
Did you ski every day?
Yes, I tried.
And for how many days?
For about a week.
In this last situation, Mrs. Douglas was quite forthright and straightforward when answering those questions. She allows her attorney to later argue that even while trying to participate in her family's favorite activity, skiing, she still experienced a lot of pain. So remember, don't offer more information than the question requires. But on the other hand, don't be evasive. A skillful attorney will generally get the information they want and may discredit you in the process. Another problem area is guessing at the facts. When a deponent begins to guess or tries to answer when they really don't know, they're asking for trouble. Just because a question is asked doesn't mean you have to have an answer. This is especially true when discussing issues of time, distance, and speed, such as in this example.
Mrs. Douglas, how far were you from the intersection when you first noticed the Howard vehicle?
I was maybe 20 yards away.
And how fast were you going at that time?
I was going between 25 and 30 miles an hour.
How much time elapsed between the time you first saw the Howard vehicle and the impact?
Oh, I really couldn't say.
Well, was it about a minute? Surely you could tell me that.
No, it was much less.
Between 30 seconds and a minute?
Less than that, I think.
Well, was it 10 seconds?
Yes, I guess that sounds about right.
Mrs. Douglas was sure of her distance and speed, but really did not know how long it took her to get to the intersection after seeing Howard's truck. Her mistake was in letting the lawyer put words in her mouth and then guessing about the time. This has put her testimony about distance and speed in doubt because the numbers are not consistent. For example, if she was going 25 miles an hour and she really did have 10 seconds to react to Howard's vehicle, she should have had plenty of time to stop. So the opposing attorney might conclude she wasn't paying attention. Be sure to review the facts of the case with your attorney so there's no confusion about what happened.
How much time elapsed between the time you first saw the Howard vehicle and the impact?
I'm not sure.
Well, was it about a minute? Surely you could tell me that.
No, I really don't know.
Between 30 seconds and a minute?
All I can tell you is that I don't know.
In this last example, not only did Mrs. Douglas not guess at an answer, she also did not let the attorney suggest an answer. Some difficulties arise not from how a deponent answers, but from the question he or she is asked. A witness should not try to answer a question unless its meaning is absolutely clear. For example,
When driving on the preferential road, Mrs. Douglas, You didn't look to see if Mr. Howard was stopping or not, did you?
Yes. I mean, no. No.
First, Mrs. Douglas doesn't know the legal meaning of the word preferential. Let's look at that question. No matter how she answers this yes or no, it will be unclear whether she's saying she looked out or not, or whether she saw Howard or not. Don't be afraid to ask what a word means. And if you don't understand a question, ask for it to be repeated, clarified, or put in plain English.
What do you mean by preferential road?
A major thoroughfare.
And can you repeat the question?
I agree, counsel. The question is ambiguous.
A deponent in Mrs. Douglas's shoes could easily become angry at being asked so many questions about her own driving when she feels Mr. Howard is to blame. The danger is that a deponent will begin to advocate or embellish his or her case.
After you saw the Howard truck and before the time of impact, did you turn your steering wheel to the left or right?
How can you ask something like that? There was no time. I didn't have time to do anything.
Did you apply your brakes at any time before the impact?
How could I? It all happened so fast. I had the right of way, and this guy came through a stop sign and hit me. Look, I never speed, and I always look out and yield to others.
Mrs. Douglas's advocacy may do her case more harm than good by overstating it. Using words like never speed and always look, she might not be as believable. To show the importance of being clear about the facts during a deposition, here's an example of how a witness's words can be used against her months later at the trial. After her attorney has finished asking questions, Mr. Howard's attorney will have an opportunity to cross-examine.
Mr. Brennan, do you have any cross-examination?
Yes, Your Honor. Mrs. Douglas, your testimony a minute ago was that you were going 20 miles per hour when you approached the intersection. Is that right?
Yes.
Mrs. Douglas, do you recall coming to my office with your attorney about a year ago to give a deposition in this case?
Yes, I do recall that.
Your Honor, may I approach the witness with that deposition?
You may.
At that time, Mrs. Douglas, I asked you some questions that you answered under oath, correct?
Yes.
Would you look at page 17 of your deposition? I would like you to read lines 5 through 10 silently as I read them aloud, and then I'll ask if you gave these answers to the questions. Question. Now, Mrs. Douglas, how far were you from the intersection at the time you first noticed the Howard truck? Answer, I was maybe 20 yards away. Question. How fast were you going at that time? Answer, I was going between 25 and 30 miles per hour. Mrs. Douglas, did you give those answers to those questions?
Yes, I did.
That will be all, Mrs. Douglas.
On the witness stand, Mrs. Douglas's testimony differs from her deposition about how fast she was driving, maybe casting some doubt on her story. You can see how important it is to be clear and consistent about every fact that you testify to during your deposition. So far, we've discussed guidelines concerning the volunteering of information, being evasive, guessing at facts, handling a misleading question, advocating a case, and being consistent in your facts. Now, let's look at another case to see how the guidelines we've discussed might apply to another type of situation. A house painter, Arnold Coptis, is suing a Mrs. Bernice Hill for money that he argues she owes him for painting her house. Mrs. Hill admits that Mr. Coptis painted her house, but argues he used the wrong color on the house. Mrs. Hill's attorney is deposing him. This time, perhaps you can analyze what problem the deponent is creating for himself. Mr. Coptis is unhappy at having to spend the morning answering questions. He figures he'll get done faster if he tells the opposing attorney everything he thinks she wants to know.
Mr. Coptis, did you and Mrs. Hill decide on a color for the house?
She told me she wanted a light gray. So I mixed up some samples, put the colors on some pieces of wood, and showed them to her. She picked out the color she liked. In fact, I've got the sample out in the back of the truck.
Good. Now, when was the first time Mrs. Hill expressed dissatisfaction to you about the color you were painting her house?
It was about 3 days into the job when Mrs. Hill got back from her weekend trip. I was just about through, and she tells me the color was too dark. Well, I was flabbergasted because just a couple of days before, she talked to my wife on the phone when she was trying to get a hold of me.
In answer to both questions, Mr. Coptis volunteered information and went beyond the scope of the question, telling the opposing attorney more than he asked for, and has perhaps weakened his claim. Using the same fact situation, let's look at another guideline to keep in mind. If your attorney makes an objection, it's not time out for you. On the contrary, it's time to pay close attention to the objection made by the attorney.
Mr. Coptis, when were you substantially finished with the project?
Well, it was
I
about...
object. That question is vague and confusing.
I can answer
no,
the
wait,
question.
Arnold, I want an objection on the record.
All right, counsel, just what is it about the question you find vague and confusing?
Well, that term substantially could be misleading. Do you mean done completely, or done with the painting, or cleanup? Or how about work done by Mr. Coptis' associates?
Okay, I'll withdraw the question. Mr. Coptis, on what date did you or your employees finish applying paint to Mrs. Hill's house?
Well, we finished with the painting part of the job on April 18th.
Mr. Coptis was getting a message from his attorney to distinguish the painting from the cleanup in his testimony. Throughout your deposition, pay close attention to everything that takes place. There are a few other subjects you may want to discuss with your attorney, too. Ask him or her about the opposing attorney's personality and style. Lawyers use a variety of techniques to gather the information they need. If an attorney is friendly and nice, it's maybe because they think it will help them. Be polite, but don't get chummy. Stay alert for every question. At the other extreme, an opposing attorney may try to anger you with sarcasm or intimidation. Try to stay cool and stick to the facts. Your own attorney can and will protect you. The opposing attorney may be aggressive, rapidly firing questions at you, developing a fast pace. If that happens, just go at your own pace. Pause before answering questions, and think it over before you speak. We've given you a lot of advice, and it may seem hard to keep it all in mind. But remember, when giving your testimony, focus on understanding the questions and stating the facts in the case as you know them. What if you should want or need a break during the deposition? Just ask. You may have one. Now let's go back over the guidelines one more time. Wear clean, neat clothing. Dress as you might for a business meeting. Relax and be polite, but not overly friendly. As you answer, stay within the limits of the question. Don't volunteer information. Be forthcoming and truthful, even if you think it might harm your case. Don't be evasive. Don't guess at facts. If you don't know a given fact, just say so. If a question is misleading or confusing, ask for clarification. Don't advocate your case. Be consistent in your facts, and pay close attention to any objections made by an attorney. Finally, be sure to go over your case with your attorney and discuss any special instructions he or she might want you to have. And good luck.